Right? Let's go on. No repeal of an enactment is necessary. Since an unconstitutional law is void, the general principles follows that it imposes no duties, confers no rights, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. A contract, did everybody pick up on that keyword, contract? A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, the Constitution, it is superseded thereby. Since an unconstitutional statute cannot repeal or in any way affect an existing one, if a repealing statute is unconstitutional, the statute which it attempts to repeal remains in full force and effect. And where a, well, what did I say there? Remains in full force and effect. Is the Second Amendment in full force and effect? You better believe it. Okay? Now what is it they don't understand about infringed? And where a statute which it attempts to repeal remains in full force and effect, and where a clause repealing a prior law is inserted in the act, which act is unconstitutional and void, the provision of the repeal of the prior law will usually fall with it, and will not be permitted to operate as repealing such prior law. In other words, the law stands always. The real law, the Constitution. The general principles stated above apply to the constitutions as well as to the laws of several states insofar as they are repugnant to the Constitution and the laws of the United States. And let's see if 54 will confer. Kuhn versus Berry, but I can tell you Marbury versus Madison is higher than that, but I'd be willing to bet you they cited Marbury in that. Moreover, a constitution of a statute, a construction of a statute which brings in conflict with a constitution will nullify it as effectively as if it had, in its expressed terms, been enacted in conflict therewith. So, anything passed in conflict with the United States Constitution is clearly unconstitutional. It doesn't take a college professor graduating magna cum laude from Harvard to figure these things out. All you have to do is read. That's why God gave you eyes now. The actual existence. Well, let's go to 257. 257, same book, 16th Am Jurisprudence. The actual existence of a statute prior to determination that it is unconstitutional is an operative fact and may have consequences which cannot justify being ignored. When a statute which has been in effect for some time is declared unconstitutional, questions of rights claimed to have become vested, of status, of prior determinations deemed to have finality and acted upon accordingly, of prior determinations deemed to have finality and acted upon accordingly, and of public policy in the light of the nature both of the statute and of its previous application, demand examination. All right? It has been said that an all-inclusive statement of the principle of absolute retroactive invalidity cannot be justified. Obviously, it would be ex post facto. An unconstitutional statute is not necessarily a nullity. It may have indeterminate consequences binding upon the people. All right? So you have to pay attention to what's going on. Now, let's get a few more and we're out of here. Section 258. I'm just going to read the important section here. On the other hand, it is clear that Congress cannot by authorization or ratification give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. Does that make sense to you? In reality, it would be what? A nullity. Why? Because it's in conflict or repugnancy. It'd be in violation of Marbury versus Madison, all right? Now, are you starting to see the gist of what's going on here? There's just one more, I think, and we're out of here. All right, Section 260 of the same 16th Am Jurisprudence. Now, folks, head down to a law library. The books are usually green or red in color. They're kind of thick. Ask the librarian where Am Jurisprudence 2nd is stored. Go on over there, grab the 16th volume, start at Section 1, and just start paging through to Section 300. I'm telling you, you won't believe it. We're going to look at Section 260. Although it is manifest that an unconstitutional provision in the statute is not cured because included in the same act with valid provisions, and that there are no degrees of constitutionality. In other words, it's either constitutional or it's unconstitutional. There's nothing like, it's kind of like half pregnant. There's no such thing, all right? So that an act is either constitutional or it is unconstitutional, okay? So if you got statute here and most of it's constitutional and a part of it's unconstitutional, guess what? It's all unconstitutional. So what we got here is a crime bill. And we got part of it is constitutional and part of it's unconstitutional. Obviously they had no authority under the Second Amendment to fool around with the right of the people to keep and bear arms. They couldn't demand that the people not possess certain firearms. So this directly applies to this crime bill. Obviously, part of the bill is constitutional and the other part is not constitutional. So what is the end result? The whole bill is unconstitutional. Does everybody see that? Excuse me. Now I want you to start looking at these things and I want you to start hammering these guys, and don't let these guys pull this kind of stuff. Hook them. Go over there and collar them. Say, hey Charlie, why don't you step over here for a minute? I want to check out something here. I mean, you would if they had your wallet. Wouldn't you? Does that make sense to you? Now we're going to get into a unique argument here. For the last half hour I've been trying to hammer home the power of this book. This book right here. Okay? I'm trying to hammer home the power of this book to teach you that this is the most valuable book in your whole life. If you know what's in this book, I am telling you, you are in full possession of your American citizenship. If you don't know what's in this book, I am telling you, you're going to be a slave, subject to the whim of extrajudicial people who want to tell you what to do, when to do it, and how high to pack it. Now, my honest philosophy to you is, as a kindness and a Christian to you, I tell you, learn this book, just like you would your... Any rights? I love it when these guys tell me I don't have any rights. I said, well, if you believe that, let's go to court. And on the end of the day, we'll see who owns who. But I'm going to tell you right now, if you violate any of my constitutional rights, I will sue your socks off and I will attach everything you own, bank, business, and home. And I'm telling you, I'm the one your mama warned you about. So you damn well better listen. Do not violate my rights, because I will come after you, and I will take care of business, and I will do what is necessary and proper, and I will pull every stop out, and I will go dig up every nut, bolt, and screw, and when it's done, you will find out you messed with the wrong American, because this American is not going to back down. Okay? Now, we're going to get into a real special argument. Now, this argument has taken almost 18.5 years to develop, so I want you to pay attention. Excuse me a second here. This argument is a unique concept that has been honed like a razor to a very meticulous edge so that you can understand what's going on. Obviously, we have established clearly that you have a constitutional right. And obviously, we have established that you are the beneficiary of the contract. And we have established that the Constitution is a contract in writing enforceable in the court of law. And we have established that you have a right to claim specific performance on the contract. And we have established that it's supposed to be interpreted in your favor. So if you've got an honest constitutional belief, they have to listen. Now let's take that to the next step. The next step is, can a state arbitrarily and erroneously convert your right into a privilege and issue a license and a fee for it? Now, I don't know if can you see this pretty clearly? This right here. All right. Let's start with here. We're going to start walking down this sheet. Okay. Murdoch versus Pennsylvania, U.S. Supreme Court. Now, when you want to go into the law library and you want to look up something, what you want to do is understand that Supreme Court is Trump. Okay. That's the clearest way I can explain it to you. If you got a Supreme Court case, that trumps a district court, that trumps a court of appeals, that trumps a state court, that trumps everything. So you want to deal with Supreme Court cases as best you can. Murdoch versus Pennsylvania is a unique case. It's recorded at 319 U.S. 105. That's the 319th volume of United States Supreme Court Reports on page 105. So when you go to the law library, go into U.S. Reports, ask the little gal there, or the little guy that's behind the counter, where is the United States Supreme Court Reports? They'll tell you right where it is. You grab volume 319, you turn to page 105, and it'll give you the case of Murdoch versus Pennsylvania. Murdoch versus Pennsylvania is a real unique case. And I'm telling you to read the case.